Calling 16 CV 1523 MCE, Anglesey versus Davis et al. This matter is impounded for defendant's motion for summary judgment. Raid docket number 25, Your Honor.
Good morning, Your Honor.
Good morning. Let's have the plaintiff's appearance first. Can you state your full name, sir?
My name is James Anglesey. I'm representing myself.
Morning, Mr. Quillisi.
Morning.
Have a seat.
Morning, Deputy Attorney General Amy McTavish. I'm appearing for Mr. Roman on behalf of officers Davis and Anglesey.
Good morning, Ms. McTavish. Mr. Quillisi.
Yes.
I think you seem to have a pretty good grasp of the mechanics of how summary judgment works.
Okay, thank you.
The defendants gave me their statements of undisputed facts, and I appreciate that you also provided a very easy to follow chart of the facts as you understand them. Let me lay out for you what I think the issues are I have to decide, and then I'll give you both a chance to discuss them briefly. First, on your claim of unlawful arrest.
Yes.
The first point that I want to make to you, and this is just background information for you, and you may already understand this, but I just want to make sure that it's clear. The standard for arresting someone is much, much lower than the standard for charging them with a crime and convicting them of a crime. So it is not uncommon for a person to be arrested as you were arrested and then to have charges dropped because the person's not guilty, right? They didn't do anything wrong. The fact that someone is ultimately determined not to be guilty of a crime, or if a DA or even the police decide there's not enough evidence to charge them with the crime, doesn't mean necessarily that the arrest was illegal. The arrest itself is only illegal if a reasonable officer at the time of the arrest, given all the facts and circumstances, would have known that there was no probable cause. And probable cause is a very low standard. So I don't disagree with you. It looks to me like you weren't driving drunk.
Yes.
But that doesn't mean that the officers broke the law by arresting you, right? The question...
I'm not really, if I can comment.
Go ahead.
I'm not really arguing the arrest as much as more as they submitted papers to the DMV, because that's kind of where damages kind of came out of. I mean, the admin per se actions, I think they have their own burdens because it's not criminal law and administrative law, which is all complicated in itself.
Right. And your problem there, again, I'm just saying this for your background information, is that the only defendants who remain in the case are the two officers. And under the civil rights statute, they can only be liable for things that they themselves did wrong. So any consequences that DMV imposed, having learned of your arrest, is not something that they caused directly, right? And the reporting is something that is required by law. The reason that the defendants are raising qualified immunity as a basis for summary judgment is that even apart from what I just finished explaining, which is that an arrest that doesn't lead to charges isn't necessarily illegal, in order for you to hold the officers liable for anything, you have to show that what they did violated your constitutional rights, either by arresting you without probable cause. I don't know what constitutional right of yours it would have violated to make a mandated report to DMV. But even if you could show me that that was somehow illegal for them to do.
I mean, from what I presented in that little cutout from the DMV, the CHPA manual says you're not being supposed to submit these documents unless he's .08. So, I mean, I don't know why they even submitted the motion the first time, the second time, I don't know. I mean, I'm kind of just leaving that. I mean, I'm not hearing an argument why someone could submit .08 when you're not .08. If there's some kind of legal argument there, I just haven't heard it yet.
Right. And I'll let Ms. McTavish address that question. Just, again, so that you understand how the court has to evaluate the situation.
It's complicated.
Yeah, it can be. And so as the plaintiff, it's on you to show not just that what the officers did somehow didn't properly follow the vehicle code or didn't properly follow procedure, but that it violated your constitutional rights, which is a whole different bar. And then on the issue of qualified immunity, see, even if a police officer violates someone's constitutional rights, they can only successfully be sued if at the time that they did the thing that violated your rights, the law was so clear that what they were doing was illegal, that any reasonable officer in their position would have known it was illegal. And I'm not aware from your briefs of any rulings of the Supreme Court, for example, or rulings of the Ninth Circuit that made it clear to a reasonable officer on the date you were arrested or your car was impounded that what they were doing violated your rights. So that's what I'm struggling to sort out, because that's the question I have to answer.
Okay. Well, I mean, the cause of action came out of, I mean, he filed papers for .08. I was not .08. So everything that happened from that action, I mean, kind of just, and then he arrested me on that action. He has some kind of duty of care just to make sure I'm .08, because the DMV, I contacted the DMV and they do not hold administrative review hearings within 30 days because they assume the officer has the evidence. So no one does any review at all. So, I mean, this could be like a hearing if I had a minute just to show. I mean, from the evidence presented, I mean, I wasn't .08. If an officer reasonably believed in a similar situation, another officer, which I've talked to and had interviews I didn't submit at this point, it said it's more likely than unlikely if the officer arrested someone on the street, they're going to be under .08, and then they go book them in jail for a blood test, and that's going to show .08. I've heard on multiple statements that is more unlikely than likely. So another officer in a similar situation, I mean, I'm not an officer, but if someone reviewed a bunch of these cases, it would show another officer would not charge someone with .08 if they were not .08.
No, I think I'm following you. There is a distinction that can be difficult for non-lawyers to appreciate, I think, though, between an officer not following best practices or not following policy and doing something that's unconstitutional. And in the context of a Section 1983 lawsuit, where a defendant gets qualified immunity, what you have to show is that it would have been obvious to the officers that what they were doing was unconstitutional. And when you were talking about why you think they were wrong in submitting the paperwork to DMV, you used the phrase duty of care, which is a legal term that's used in usually the context of negligence. Like if a doctor treats you in a way that violates the duty of care that a doctor has, that might be medical malpractice, which is a form of negligence. Or if your neighbor doesn't take due care with your property, you could sue them. But those aren't civil rights violations. And those kinds of lawsuits would not be brought in federal court.
I know they've said in the documentation certain stuff is vested with the DMV. Apparently, I was supposed to request a hearing with the police department regarding the impounded my vehicle, which is like a whole separate hearing, which I did provide the form showing that my car was impounded. I mean, I'm representing myself. I've dealt with the police. I mean, I've been kicked out of multiple buildings just asking too many questions, including the police station, which arrested me. So if I'm supposed to go there, request a hearing, request evidence that shows they're guilty, they just weren't giving this stuff out.
Right.
I've been kicked out of the DA's office just for requesting my toxicology report. I know there was a whole discovery process I was supposed to do within the court, but I didn't want to file a lawsuit without actually knowing I had evidence. So I was doing public information acts before the fact just to make sure I had a case. I mean, I wouldn't file a lawsuit, but I didn't think I could actually win. So I believe the evidence is all here to oppose this motion for summary judgment just from the disputed facts. I mean, they said that they didn't impound my car. I provided documentation, the Form 180, it shows they did impound my car. So, I mean, I would love to just argue my whole case right here and get it over with, but since it's a motion for summary judgment, I mean, I'm open to questions. I mean, if it can further, like, resolve this issue, I mean, I'm open for statements, but it's kind of limited because, you know, I am representing myself.
Yeah. I understand that, and I appreciate how much work it's been for you to gather the information and bring it here. I also have a fair amount of sympathy with how difficult it is for people to negotiate the DMV bureaucracy and the impoundment process. The consequences of this kind of an arrest can be a huge pain in the neck to deal with. And, you know, I accept everything you're telling me at face value about the runaround you got from various agencies. But none of that is relevant to the legal questions I have to decide on the motion.
So when it comes to, it's coming up to the 4th Amendment and the 14th Amendment, I'm not sure why we didn't really discuss the 14th Amendment. I know the 4th Amendment is search and seizure. I know they did make an argument that the search, they didn't search it, but I'm not like going to claim that because no cause of damages came out of them searching my vehicle. So the cause of damages came out of them impounding my car.
Okay.
So, I mean, I believe that's falls under the 4th Amendment. And I quoted what Brewser versus Beck. I mean...
Yeah, we'll get back to Brewster in a minute so that I don't completely lose the train of discussion. A moment ago, I want to ask Ms. McTavish if there's anything to add to what's in the papers on the issue of the paperwork, because I'm not really clear on the process by which, after someone is arrested on suspicion of DUI, the DMV is notified. Can you walk me through that, please?
Your Honor, my apologies for stepping in for Mr. Roman today. Yeah. But my understanding is with the arrest, especially in this type of case where it's was kind of a drug and alcohol combination, the CHP does complete the forms and submit them to the DMV, and then it's out of the CHP's hands at that point. Then Mr. Kellichi can talk to the DMV regarding what happened with this paperwork, but the CHP has no authority to revoke that, to pull it back. And so the starting point, though, would be the probable cause for the arrest. And so when we get back to qualified immunity, we see that the CHP officers in both of these different arrests had probable cause to believe that they had the authority to fill out that form and to report to the DMV as was their duty. So going, again, back to what the allegations are against the officers, what the standard is under the 4th Amendment, with the putting that process into play was not a violation based on the probable cause that they had.
All right, thank you for that. Any response on the probable cause argument, Mr. Kellichi?
I mean, I did submit some stuff about the...
And I've read what you've submitted, so you don't need to...
Just a statutory background, I mean, straight per se actions. I mean, under the code, it says, 13353.2, the vehicle code says you got to be 0.08 to submit these papers. I mean, it's like mathematical. I'm not sure. I've never heard a counter argument why someone would submit this stuff. So by the preponderance of the evidence that I was not 0.08, the evidence they had at the time I was not 0.08.
Well, I'm not, as I sit here right now, because most of my research is back in my office, going to be able to cite to the specific sections of the vehicle code I'm talking about. But we all know that the vehicle code has several related sections about impaired driving. Mm-hmm. So there's the section that says it's illegal to drive when your blood alcohol is 0.08 or above. It's also illegal to drive when, regardless of your blood alcohol level, or even if they don't know your blood alcohol level, you are impaired by alcohol or illegal controlled substances or legal controlled substances or any combination.
Well, from my understanding, may I interrupt for a second?
Actually, don't interrupt me. So it's illegal to drive when you're impaired for any of those reasons under any of those standards, and whenever anyone is arrested on suspicion of any of those forms of impaired driving, there's a requirement that it be reported to the DMV. and then it becomes a matter of administrative proceedings within the DMV, what to do about somebody's license, and that's independent of the law enforcement officers. So your claims right now are against the CHP officers, and it seems to me that they were doing what they were required to do in simply notifying DMV that you had been arrested on suspicion of impaired driving. And it's absolutely true that later the blood alcohol test came back showing that you weren't under the influence of alcohol. But at that point, it was out of the officer's hands. So does that make sense to you?
I mean, I can't see that because the toxicology reports take so long as they do. I mean, how is the DMV? So I've talked to a couple of DMV officers and this supervisor of the court that the DMV handles alcohol only. The courts do drugs. So them submitting this stuff with the DMV, I mean, it wasn't even being available. On-the-spot suspension is your .08, and they can't, like, use evidence they believe that will exist in the future. That's not probable cause. I mean, arguing the difference between like probable cause and like reasonable suspicion, preponderance of the evidence. From my understanding, it all comes down to like 51% of likely probability of being more likely than unlikely. If I'm like 0.00, I think it's going to be more unlikely than likely that I would be 0.08, and that did not meet the burden of probable cause.
Well, the issue of probable cause is one thing, and then the notification by the officers to the DMV is another thing. It sounds to me like you're more concerned about the latter, right? So on the question of qualified immunity, what I have to decide is whether there was clearly established law that put the defendants on notice that it was a violation of your constitutional rights to send that notification to DMV under the circumstances. So that's the only question. I'm just letting you know that that's the only question that I am, or that any judge would be permitted to ask at this stage, or it's a key question, right? Not whether what the officers did was correct or whether what the DMV did was correct, but at the time that the officers did what they did, arresting you or submitting the forms to DMV, was it clearly established that that was going to be a violation of your constitutional rights? And I'm going to take this moment to just back up for a second and explain something to you that I didn't at the beginning, because this is the first time you've been in my court. And that's just a process piece to explain to you my role in this case and Judge England's role. I'm a U.S. magistrate judge. He's a U.S. district judge. We are both assigned to your case, and we each do a different piece of it. If this case went all the way to trial, Judge England would be your trial judge. On the summary judgment motion, I'm the one who's going to think through it and analyze it and write an explanation of what I think the result ought to be under the law. But instead of ordering directly that the defendant's motion is granted or denied, instead I will make a recommendation to Judge England about whether the motion will be granted or denied, and he's going to have the final say. But this is the only
So we're still arguing what qualified immunity at this point, because even before we go to trial, we have to decide, is that still an issue?
There won't be any decision about whether this goes to trial until after this motion is resolved. I'm just explaining that at the end of today's discussion, and we'll talk for a few more minutes about the motion, but what I'm going to do is take the motion under submission. Like, I'm not going to issue a ruling right here in court. Instead, I'm going to write a document that analyzes the motion and gives you all of my reasoning on paper for your benefit.
So you're going to give her like a recommendation that you're going to review?
So it will be a written analysis of the motion and a recommendation to Judge England, and you will have an opportunity to submit in writing any objections that you have to my recommendation. So all the things you think that I get wrong, you can write down and send to Judge England. He will not have you come to his courtroom to argue again, but he will read all the objections that you submit and any objections that Ms. McTavish submits and my findings and recommendations, and he'll be the one to finally order one way or the other about the motion.
Okay.
Clear on the process, sir?
Is that the normal way it's done?
Yeah.
Okay, yeah, that's fine.
Yeah, that's the normal way it's done when a case is referred to the magistrate judge for pretrial motions. And here in the Eastern District in Sacramento, all cases that have an unrepresented party like yourself are referred to the magistrate judges.
Okay.
Yeah. So I just wanted to make sure that was clear. So getting back to the other point, you raised the Brewster case. Ms. McTavish, I know you've just recently come in to the case and are here to argue a motion you didn't brief. But are you in a position to give me defendant's position on Brewster?
Well, Your Honor, actually plaintiff's opposition set out that Brewster is factually different because this was not the car that actually was being driven by the person who had it impounded. So factually, it's very distinguishable. In that case, it was someone who was driving the car. They got the car impounded. Someone else owned it. And Mr. Kalichi has never claimed that this was not his vehicle. So going to that type of seizure. And secondly, the car was only impounded once. It was once held, and then the second time it was impounded after DMV, after he had his license suspended for excessive blood alcohol. And there's no showing that there was an illegal impoundment, that there was no reason to impound it at that point, too, in the July arrest. So, and I actually want to get back a little bit because the issues that we've talked about today have gone far afield of what's actually alleged against the officers. We have been discussing what is basically negligence today, and it's paramount that a defendant does not have to defend against allegations that are not actually brought against them. And that seems to be the theme today. We have 3 different theories against the CHP officers, one for false arrest, and the second being for the search, and the third for the impounding the vehicle. There's been no allegation of negligence. We've gone way off the beaten path here, and so I would like to...
And my discussion of negligence was only to illustrate for the plaintiff the distance that there is between allegations that go only toward negligence and proof of a constitutional claim, which you're quite correct, Ms. McTavish, is what's before the court in this case.
Thank you.
Yeah. On the issue of the Brewster case, sir, I suspect that Ms. McTavish is correct that the differences in the facts mean that case doesn't help you very much. The Ninth Circuit, hear me out and then you can respond. What I focused on when I read the case in particular was that the court specifically said in that case that the police initially having the car impounded was perfectly legal. It was the failure to release it later to the true owner that was the problem. So I don't see how that helps you establish that the initial seizure of your car was illegal.
So, I mean, I've researched this case to the best of my ability with the tools I've had, and the Brewster versus Beck is the most similar case I've come across, even with my car being repossessed, just like in the Brewster case, by my finance company unjustifiably. I don't know why they do it. They just do it. It's so common. It's on the record of being common. So, yeah, they repoed my car. Then I immediately try to get my car back, and then it says it has a 30-day hold, just like in the Brewster case. So, and I don't know at that point. I mean, I'm not an attorney. I wasn't an attorney back then either, but I'm supposed to request a hearing. I have no evidence at that time to even prove my innocence. So, I mean, untimely hearing, I think that's all what it came down to the Brewster case, that there was a lack of a hearing. So, and this case is similar, even with the repossession of my vehicle, just like the Brewster case. I mean, I couldn't request a hearing, and if I did, I had to go to the police, and it's just a bad argument at the place.
Okay. Well, I will take another look at the Brewster case, and I'll read it very carefully and see whether it provides any support to your position. All right. Thank you. Ms. McTavish, is there anything further for the defendants?
No, Your Honor, submitted.
Anything else you'd like to say, Mr. Quilici, before I take the motion under submission?
I mean, we've been arguing like false arrest mostly.
And the impoundment, I know that you care a lot about.
Yeah, I mean, the false arrest, I'm not really... I know there's different qualifications for arrest. You can like arrest someone for anything, but you're going to go before the judge. And when they filed these papers with the DMV, they took my car with no hearing, no oversight, no anything. I believe under the Fourth Amendment and due process, there's supposed to be some kind of review so these types of things don't happen. Because if when I was arrested, when I went to court, the criminal court, I mean, it kind of just things handled themselves out because there was a hearing. I mean, I didn't like go to jail for like extended period of time, but they took my car and a person, seizure of my person or my car. I'm not really arguing the search because no damages arose out of that. So why would I claim it? I mean, so it's mostly, I'm not sure why we didn't speak more on the 14th Amendment and just mostly the Fourth Amendment. I know Fourth Amendment mostly deal, like you said, arrest, but the seizure of my car without due process, without the officer knowing that I was not .08, he didn't have probable cause at the time to suspend my license and confiscate my license, which also the seizure of my license is, you know, Fourth Amendment violation. So, I mean, I just hope I get a good recommendation, you know, that, I mean, there was no hearing, there was no oversight, just like in the Brewser case, and.
Well, I just want to point out to you that the reason we're talking about the Fourth Amendment to the exclusion of the 14th Amendment is that your complaint had previously been construed as stating Fourth Amendment claims and not containing facts that gave rise to a 14th Amendment claim.
Well,
So I'll take a look at the past screening of the complaint. Thank you very much. What I'm looking at is a copy of the screening order. Let's see. So in your original complaint, you made the allegation that your car was seized without due process. The reason that your complaint was never served on anybody at the DMV, you never named a defendant, right, who was responsible for the due process violation.
I mean, the printouts I've had, I have a lot of like DMV records, right. And I have like the people who signed up, I can like quite read their signature, so I just use their abbreviations. I was on the DMV printouts who did these hearings. I involved the DMV because I requested a hearing for, they're supposed to, under certain codes, they're supposed to say if it's unjust or not. I was going to use that evidence as in my other hearing for the Government Claims Board, which they denied my hearing under like false pretenses, saying, I'm the DMV, they did a lot of things.
Well, I understand the problems that you've had with the DMV, and again, I think most people have had their frustrations with the DMV. I know it can be a difficult system. What I'm saying, though, is that in this lawsuit in this court, you never named as a defendant an individual from the DMV. So you don't have a claim in this lawsuit against them, because you can't make a claim in a lawsuit unless you identify a defendant and make allegations about what that specific defendant did to you. So even though I know you've always been concerned about the due process DMV issue, your complaint never actually sued anybody over it. Even though you talked about it, you didn't sue anybody over it. So the claims that are before me are Fourth Amendment claims against the two CHP officers only. And that's what I'm going to analyze under the summary judgment standards and review for qualified immunity. As I explained before, I will be issuing findings and recommendations to Judge England, and you'll have an opportunity to make your case to Judge England as well if you need to in opposition or objection. All right. Thank you. The motion's under submission.
Thank you, Your Honor.
Okay.
Thank you.
All right, thank you, Your Honor.
You're welcome. Have a great day.